People say I don't need a mic.
You don't.
See? But I really, President Lincoln, the saying, you know, to care for him who shall bore the battle, and for his widow and his orphan, because I truly have a heart and a passion to understanding the VA. We're going to talk about New Year's resolutions and ones you should keep. The reasons why New Year's resolutions are fail. You're not alone in making resolutions. 45% of Americans make at least one resolution every year. You might only have 8% of the people actually keeping the New Year's resolution that they commit to. I admit it, that's me. I always say I'm going to go on a diet. The second one is that time crunches. We're all busy, we're all working, we've got our own life and everything. So 40% say that it's just hard to juggle too many activities. When you live, where you live also determines that. The geography, it makes a difference. And we found out that 65% of the residents in the Sunshine State, they keep their New Year's resolutions. Go figure. So you guys can't prove them wrong here, okay? And January is usually the really critical month. 1 in 3 people won't last the 31 days of the New Year's resolution that they make. 3-month mark is a major accomplishment. 40% of the people who made their New Year's resolutions has kept them to March are less likely to drop out. And the money is an even better incentive. 80% report success if there's money on the line, with money being the best motivator. So this is what we're going to do, is we're going to help you look at that area also. As an AG, oh, you've got all of our pictures there.
You look a little different.
I know, isn't it scary? What we look at is, when we do this, is we look at client-centered planning. Because no matter what I do as a care manager, no matter what Jody Murphy would do as the elder law attorney or Kevin Webmore on giving the financial side, everything that we look at and we do, it centers around you and what you're wanting to accomplish. I'm going to go over the healthcare side, which is what I do as an aging life care professional. I do an actual intake. And I can spend anywhere from an hour to an hour and a half going over our intake, because I'm looking at things from the healthcare side, the legal side, and the financial side. So looking at all of that, I get the information or a picture, and it's a fast picture, but a picture of what's going on. And I look at primarily the healthcare side. When you were at the doctor last, what do you doctor for? When was the last time you were in the hospital? Were you ever in a rehab situation, or did you have home care at any time? Those are key factors that when I give the intake to the attorney and the financial person, they need to know this kind of stuff when they're looking at what options are out there to help you. Decisions, decisions, decisions. I love this, because there's no place like home. And what I would really like to do is just stay right at home. And you know, we do have that ability, or you do, with proper planning, to look at staying at home. I always tell my people that I work with, I will help you find the benefits and services to keep you where you want to be, as long as you are safe. And you will find that each one of the people here on the panel, they will say they will help you get whatever you're wanting, as long as you're safe. Our homes represent security and independence. There are things like home modifications that you can help to keep you at home for a longer period of time. There's also services that you can bring in, but there's also senior apartments, independent living communities, and adult care homes. With these, they all come with a price, and those prices will help you decide, by looking at your personal situation, which one would be the best fit for you. There's also assisted living, skilled nursing and long-term care facilities, retirement communities, and continuum care facilities. And like we said, each one of them has a price tag. But if you are able to live independently, in your home and services can come in, we try to look at doing that. But we plan for what would happen next. And with doing that, we may find that you may need more than just being at home. You may need in an assisted living facility. So that's where that talk would come into where we would do the planning side on that. There's also home health care, non-medical services, and hospice. One of the things that we look at too is if you want to age at home, you have the ability to age at home, we look at non-medical services or home health coming in to help you with maintaining your safety there in your home. Hospice is always near and dear to me because hospice, not only will they help you remain at home if that's where you would like to be and you have that support to help you as well as hospice, then they will be all for it. But if you need to go to a facility or to the hospice house, you have that ability to do that too because they're there to support you and your families. That's what I'm saying. All of these choices are available to you, choices everywhere. So it does get overwhelming. And what my job is as that care manager or aging life care professional, my job is to help you put a plan in place that you are comfortable with. And at the time when you're not able to take and speak for yourself, that plan that you put together with the attorney, with the financial person, with myself, we can help your children go through and honor your wishes. I already went all over that, sorry. Now I'm going to, because you got my end of what I do, after that intake, with your permission, I asked to send it on to the elder law attorney and also the financial person to have them look at it on the benefits and legal side. Now, I'm going to go ahead and introduce you to Jody Murphy. Jody, I know this is a lot here and that's only a small part of her bio, but I'm going to go off the cuff besides this here. Jody Murphy is a certified elder law attorney. She is also a member of Wealth Council. She is also an accredited VA attorney. And I have worked with Jody now for about a year, and Jody has always been there that when we have a question, concern, she's taken the time to explain to the children why we are looking at doing what we're doing. And in a crisis situation, Jody's been able to help us with getting the proper placement needed so that person didn't have to just depend on what was going to happen to them without help. So I'm going to go ahead and turn this over to Jody, and you get to take over the.
Thank you. Do I need to be mic'd for whoever's watching in
Yes, I will give
internet
you.
world? Okay. Yes.
Change it.
All right. I don't have a pocket. These are fake pockets. Oh, look, I can put it in there. Okay. Think we're good. So as Kim said, my name is Jody Murphy. I am an elder law attorney, and I have two offices. My primary office is in Orlando, and our secondary office is in the Villages, right next to the Charter High School. So if you're familiar with that area, that's where our second office is. For my full bio, I do have these folders up at the front if anyone would like one afterwards. And I have my full bio right inside. In addition to being an estate planning and elder law attorney, I am VA accredited, which means I can represent people to the VA. I do a lot of VA benefit applications, a lot with Medicaid applications, and getting my clients financially eligible for those benefits. On top of that, I am also the co-chair of the Florida Bar Veterans Benefit Committee, which means I teach other attorneys about veterans benefits. I'm not going to have the opportunity to get too far into VA benefits and Medicaid benefits today because Kevin will be doing that in the next round, so he'll talk to you about the VA benefits. If you do have questions though, I am more than happy to address them, and I do offer a consultation if you'd like to go over personal situations. Now, Kim had mentioned New Year's resolutions, and one of my New Year's resolutions was to do a random act of kindness for somebody unsuspecting every single month. So the first thing I'm going to do today is give out a copy of my brand new book. This is the 2018 edition of Unveiling the Medicaid Mystery, Qualifying for Veterans Benefits and Medicaid in Florida. So to win a copy of this book today, I have a question. The first person to raise their hand and answer it correctly will get the book. And the question is, of all the estate planning documents that are out there, what do you think is the most important legal document to have as an aging senior? Yes, ma'am. Power of attorney, that's exactly what I was thinking. So here you go. And we will go over the answer of why that's the most important. So when we're talking about estate planning is really a twofold process. It is the process of planning to distribute assets at death, but more importantly, it is the process of protecting your personal decision making. So the answer that I normally get to that question is a will. I have to have a will. Well, that's great when you're dead. But during your lifetime, it's much more important that you have the appropriate legal documents to name somebody who can step into your shoes to make financial or medical decisions for you. So the correct answer was the durable power of attorney. That's the legal document that will allow someone to make financial decisions, and we'll get into that in just a minute. So up here, when we're talking about estate planning, we can do will-based planning, which distributes assets at death. We can do trust-based planning, which sets up a trust for you during your lifetime that can be managed while you're alive and distribute assets at death. We can use beneficiary designations. So on things like life insurance or retirement plans, you can name a beneficiary, or the default is you can do no planning, and you can just let the state make decisions for you. If you do no planning, then the state will decide who can make a medical or a financial decision. Now, by show of hands, how many people in here assume that if you're married, your spouse would be the one making those decisions? Okay, so we have a few people in the back who do. The answer is that's wrong. And the reason why is if you have not taken the time to put in a legal document who you want making those decisions for you, the state does not have a hierarchy of who could be the person making decisions. So we all know the case of Terry Shiva, which was decided by the Florida Supreme Court in 2004. And in that case, there were no legal documents addressing end-of-life issues. And the patient's husband and mother disagreed about what should be done. So as we saw through the Supreme Court's decision, there is no automatic presumption that a spouse can make a decision for you. So if you are married, do not rely on the default. Make sure you put in writing what your decisions are and who you want making those decisions. Okay. So the power of attorney, that is the legal document that allows somebody to step into your shoes to make financial decisions for you. It is everything from accessing your bank accounts to pay bills, to making legal decisions, to handling your tax affairs, or bringing a lawsuit. Now, what we deal with most often here in Florida is the elder law planning. So planning for an unknown future. And that unknown future may involve at some point needing long-term care. And if you need long-term care, you can either private pay for it, or you can look to government benefits, like Medicaid through the state of Florida, or veterans benefits if you or your spouse were a veteran. So there are veterans benefits available for a surviving spouse. But if your power of attorney does not allow someone to step into your shoes to do planning for these benefits, you may have effectively barred yourself from doing what is necessary to become financially eligible. For example, if you are over the income limit in the state of Florida for Medicaid, so each individual has to make $2,250 or less to be eligible for Medicaid, there's a very easy solution. We can set up what's called a qualified terminal interest trust or a Miller trust to divert excess income, if you're capable. If you're not capable, your durable power of attorney can set it up if and only if your power of attorney specifically says, my agent can set up a qualified terminal interest trust for purposes of qualifying for Medicaid. And I'll give you a hint. Prior to 2011, no power of attorney said that. October of 2011, there was a change in the laws that introduced all these superpowers. The superpowers go into detail about very specific things that you are going to allow your agent to handle for you. And that includes most of the things that we need for Medicaid and VA planning. So I tell my clients across the board, if you have not updated your power of attorney since October 2011, it's time to update it. And we need to do it now while you're competent. Because once we get to a point where you're incompetent and you can't sign legal documents, there's no ability to make changes to your power of attorney. Then we're looking at a guardianship action. Yes, ma'am.
I thought I had been told that with the new change in the law, that the power of attorney can actually transfer money when you're still competent, even if you don't know it.
So what you're referring to is the removal of the springing power. So prior to 2011, we could set up a power of attorney that said, this agent can act on my behalf only if I'm incompetent. The change in 2011 made it an immediate power that the agent can act on your behalf immediately at any time, whether you're incompetent or not. So the answer is yes. Under the new laws, a power of attorney can transfer money and can pay bills and can do things, but they can't set up that income trust and transfer money into the income trust unless the power of attorney specifically says they can set up a trust. They can make gifts. They can enter into personal service contracts. There's about 25 different legal tools that can be used to qualify an individual for Medicaid or VA benefits, but the power of attorney has to specifically authorize those 25 things. So the answer is yes, it is an immediate power, but it has to specifically address it.
When we had this done, the attorney had suggested that they keep the power of attorney, that it's not, we don't physically have it, so
Right.
that's why couldn't do that. Not that we're worried about that, but that was their policy.
Sure, and some attorneys will do that because the agent can only act if they actually have the document. It's a personal choice. If you have your attorney holding your legal documents for you, that's absolutely fine, but let's hope the attorney doesn't die or go out of business. That's when we're encountering some issues is clients will say to me, I have all of these documents, my attorney has them, and I'll call the attorney's office and I can't reach them. Either they've gone out of business. I have one attorney in Orlando who was actually disbarred for illegal activities, and his files got transferred to a garage somewhere. Nobody knows where this garage is. All of my clients' documents are in a file somewhere in a garage. We can't find them. Well, my clients need them. So it becomes a problem if you don't have access to your own documents. Rather than the attorney keep it, I would recommend that you hold on to it, but not give a copy to your agent. So, and unfortunately, I have to kind of move forward with this, but there's so many questions about powers of attorney that we can go over, but that is the most important legal document when it comes to estate planning. So as I mentioned down here, the power of attorney can no longer include the springing power, and it must specifically authorize certain powers. The next document is a living will. A living will is one of our healthcare documents. This is what stemmed from the Terry Schiavo case, and a living will is the legal document that you can sign that puts your end-of-life wishes in writing. And what it states is if at any time you are both mentally and physically incapacitated, and you have one of three conditions, a terminal condition, an end-stage condition, or you're in an irreversible permanent vegetative state, by signing that document, you are stating that you do not want your death to be artificially prolonged. So in plain English, if you meet all three prongs, you don't want to be kept artificially alive on life support.
But wasn't her husband the one who made the final decisions?
So actually it ended up being the Supreme Court that made the final decision. So this went on.
The was battling it.
Correct.
And he was the one pushing and saying, I don't want her to.
Correct. He wanted her removed from life support. The mother wanted her maintained on life support. Because she did not have a living will that said what she wanted, that was signed in front of a notary, it was a guessing game. What would the patient want? If the patient is incapacitated and cannot tell you what they want, somebody has to be the one to make a decision. So for 10 years, the husband and mother fought back and forth. So ultimately, it wasn't either the husband or the mother that made the decision, it was the Supreme Court. 12 judges who had never met this woman in their life coming in. And really, at the end of the day, their decision was not based on anything personal. It was based on dollars and cents. This had been going on for 10 years, and the estate had been drained completely. There was no money to continue the legal battle. So to avoid that, put your wishes in writing. Make sure nobody has to guess what you would want. Not only does that avoid the legal battle, but it really takes the burden off of your loved one's shoulders. They don't have to carry that weight around of, did I make the right choice? Is that what my family member would want? They know exactly what you want because you've put it in writing. Now, along with the living will, there's 2 other healthcare documents that everybody needs, and this is something that I think if you're 18 or over, you need to have. One is a HIPAA release. Stands for the Health Insurance Portability and Accountability Act of 2002. In really fancy legal words, what this means is, this is who can talk to my doctors. Every time you go to a doctor or a physician, you sign a HIPAA release. Some people fill it out, some people don't, but it's specific to that physician or hospital. A permanent HIPAA release is part of your estate planning documents, and it's a laundry list of who can access your medical information and who you're waiving confidentiality for. So if you're traveling, or if something happens and you're at a new doctor, and your spouse or your children or your grandchildren need to call and find out what the situation is, if you've authorized them on your HIPAA release, the doctor will be able to talk to them. If you haven't, and if you're incapacitated and cannot provide informed consent, the doctor will be barred by confidentiality laws. So having a permanent HIPAA release that lists who you want to have access to your medical information is important. But even more important, did we miss the slide for healthcare surrogate? Okay, it may not have made this slideshow, but the healthcare surrogate is the next document, and I think it's missing from the slideshow. Healthcare surrogate is the legal document that allows someone to actually make a medical decision for you. So what it says is, if you cannot provide informed consent for your own medical decisions, this is the individual that you want making medical decisions for you. And the law on healthcare surrogate changed last year. So if you haven't updated your healthcare surrogate, it's probably a good idea to have it reviewed. The reason for the change in the law is that the healthcare surrogate used to just say, if I'm incapacitated, this is who can make a decision. What does incapacitated mean? Does it mean you can't talk? Does it mean a doctor has declared you incapacitated? Does it mean a court of law has declared you incapacitated and taken your rights away? Well, what was happening is the doctors didn't want to interpret that word. And so what they were saying to a spouse or to children is, yes, you're the healthcare surrogate. Yes, I see your name on this form, but I'm not going to listen to you until you go to court and you have your mom or your dad or your spouse declared incapacitated. Does anyone want to take a guess at how much it costs to go to court and have someone declared incapacitated? An average through our firm for a guardianship proceeding can be $8,000 to $10,000. That's because you have court costs. The person who wants to be the guardian has to have an attorney. The alleged incapacitated individual has to have an attorney. 3 doctors have to come out and evaluate the person and determine whether they're incapacitated, and they charge a fee. And then, of course, you have your typical court costs. So if we can avoid guardianship proceedings at any cost, we try to do so. So having your healthcare surrogate in place, that is who can make a medical decision for you, is important. And that change in the law last year said we no longer have to have someone declared incapacitated. It can be an immediate decision. If the person cannot provide consent for their own treatment, the healthcare surrogate can make a decision. Okay, so talking about trust, there's 2 different types of trusts, revocable and irrevocable. The difference is whether or not you have access to it. So a revocable trust is a great way to distribute assets at death. Think of a revocable trust like a basket. You can transfer your assets into it during your lifetime. It has handles, so you can pick it up and carry it through time. And typically, a revocable trust is set up so that the person who is setting it up has full control and access over the things in the basket. An irrevocable trust is also a basket, but this time it's a basket with barbed wire wrapped all around it. Usually it is used for Medicaid or Veterans Benefits planning, and that barbed wire keeps the person who set it up from having access to the things in the basket. So essentially what we are doing is we are setting up a basket, we are transferring assets into the basket, and then the person who set it up has no access to it. Maybe a child can access it, maybe a third party can, but it takes it out of the client's estate so that they can qualify for Medicaid or VA benefits. Now, depending on the type of benefits, there's pros and cons to setting up an irrevocable trust. Does anybody know what the Medicaid look-back period is? 5 years. So if we set up one of these irrevocable trusts and we're trying to use it for Medicaid, we have to wait 5 years before the person who set it up would be eligible for Medicaid. And that's because for every $8,900 that is transferred in the 60 months prior to applying for Medicaid, you are penalized from Medicaid for 1 month. So setting up a trust and transferring assets into it will create a penalty for Medicaid. Does anyone know what the look-back period for VA benefits is? I hear silence. That's because there isn't one. So right now, the VA does not have a look-back period. So we use irrevocable trusts all the time to get a client qualified for veterans benefits, because I can set up the trust today, fund it tomorrow, and apply for VA benefits the very next day, and there is no penalty. Now, there has been a proposed change to the VA rules and regulations which may implement a 3-year look-back period, but that hasn't happened yet. It's something that I'm monitoring very closely, and my inside sources say that it won't be up for discussion again until August. So right now is a perfect opportunity to start doing planning for veterans benefits because there is no look-back period. Yes?
The trust was set up before that a look-back period was put in effect. Was that trust?
We don't know. So the question is, if you set up a trust or if you transfer assets before the VA implements a look-back period, and then you apply for the VA benefits after that look-back period is imposed, will the trust be exempt? And the answer is we don't know yet. So if you are thinking about VA benefits, I do recommend we get that process started quickly. So if you're going to be using a trust, I'm also going to recommend that we apply for VA benefits as quickly as we can and not risk having a look-back period. Something that's out of our control, so we just don't know. Okay, so we talked a little bit about revocable trusts. Again, we use them to avoid probate. Anything that's in the basket that you have access to during your lifetime can transfer to beneficiaries without going through probate. But if you have access to it, it is considered your asset. So it doesn't use a separate EIN number. A revocable trust would just use your Social Security number. It's deemed to be available to you for both Medicaid and VA benefits, but there is a purpose in using revocable trusts, and that's, of course, to avoid probate. So if you're not concerned about Medicaid planning or VA planning right now, a revocable trust may be a great option to minimize any costs, expenses, or time delays at death. We talked a lot about the irrevocable trusts. We use them for Medicaid asset protection, veterans asset protection. The qualified income trust I had mentioned earlier in my presentation is to hold excess income if we need to qualify for Medicaid. And we may have a special needs trust. So if you are a married couple and one person is applying for Medicaid, oftentimes we will transfer assets from the sick spouse to the healthy spouse. I don't want to get into too much detail about numbers and things like that, but that is a planning strategy. That way the sick spouse can qualify for Medicaid. But what happens if the healthy spouse dies first? If the healthy spouse dies first and has a revocable trust that says everything goes to the sick spouse, or has a will that says everything goes to the sick spouse, what's going to happen immediately when that healthy spouse dies? The sick spouse will lose their Medicaid benefits, could possibly also lose veterans benefits as well. So a special needs trust is a very specific type of trust that is used to protect assets when you are naming a beneficiary who is receiving government benefits. Now, as a married couple, this is something that people are not familiar with. A revocable trust cannot set up a special needs trust for a sick spouse who's receiving Medicaid. That can only be set up through a will. So a lot of times clients come to me and they say, we just met with this great elder law attorney, we paid thousands and thousands of dollars, we're all set up. And I take a look at this fancy binder, and inside the fancy binder is a fancy trust. And inside the fancy trust, it says, if healthy spouse dies first, money will go to sick spouse in a special needs trust. And it sounds great, but it doesn't work. And the reason it doesn't work is the Constitution of Florida does not allow a trust, a revocable trust, to set this up. So again, those are the details that elder law attorneys will understand that estate planning attorneys may not understand. So we look at everything comprehensively. We look at your personal situation, we look at your income, we look at your assets, we look at what your goals are, what you're trying to accomplish. And the first thing that I always do when I'm working with Kim or anyone else is put a plan together for you. And the plan is going to look at where you are today and where you might be in the future. And I tell every single client, my crystal ball is broken. I have no idea where you might be in the future. But what you need to know is what your options are. So we'll look at it. What are the options if one spouse gets sick? What are the options if both spouses get sick? What are the options if a beneficiary predeceases you? What are the options if we're looking at Medicaid versus veterans benefits? So the first step in any elder law plan is to have a written roadmap. The second step is to update your estate planning documents to meet your goals, updating your power of attorney and your healthcare surrogate. The third step is to implement the plan that was put together for you. You may not implement it for 5 or 6 years because you may not need Medicaid or veterans benefits now. It may just sit there until you need it. And then of course the last step is to actually apply for benefits once the plan has been implemented and everything has properly been funded. So I think I'm running out of time. How am I doing?
You are doing pretty good.
Okay, so quickly I just want to talk about probate. Probate is the legal process to transfer assets at death. I mentioned earlier the problem that could arise if a healthy spouse dies before a sick spouse, and we could end up risking the loss of federal benefits or state benefits. Also, it's expensive, so depending on what the amount of assets going through probate are, you're looking at either a summary administration or a formal administration. The costs are going to be based on what type of probate are we going through, but typically it is a minimum of $1,500 if you have assets that are $75,000 or less, but it could be as much as 3 to 5% of the estate. And that's just court costs and legal fees. So again, my plan will always analyze how can we avoid probate. If we can avoid probate, we always want to, either using a trust or beneficiary designations. Okay, so using beneficiary designations on things like your retirement plans and your life insurance is a great way to avoid probate, but again, it can have some downsides. If you have an IRA and you've listed your spouse as the beneficiary in your IRA and you die, well, for VA benefits, that could be a problem because the VA looks at IRA assets. For Medicaid, it's not a problem because Medicaid is an exempt, IRAs are an exempt asset from Medicaid. So again, the things that beneficiary designation cannot do, what happens if your beneficiary predeceases you? We can't get detailed and say, this is the succession of how we want things. Usually it's a primary beneficiary and a contingent beneficiary, and that's it. If you have more than 2 beneficiaries listed, it gets complicated. It also can't take into account what if one of your beneficiaries is receiving government benefits. So we can't create a special needs trust through a beneficiary designation, and we also can't make distributions to minors through a beneficiary designation. So sometimes using a beneficiary designation to avoid probate is a good idea, but sometimes it doesn't work. So again, looking at that comprehensively with your entire plan is important. Okay, I think that's all that I was allocated to speak today, so I'm gonna have Kim come back up. As I mentioned, I do offer a consultation, so if anyone would like to schedule an appointment with me, you are more than welcome to, and I'll pass out my information, and I'll hand off the mic.
Turn in slides for me. Thanks. Pleasure to be with you today. First thing I want to say is I'm going to talk specifically about a Veterans Benefit Program called Aid in Attendance. But before I do that, I'm going to tell you a little bit about my theory on this whole process of planning and the team that has to be involved in this. I think that a lot of people make bad health care decisions based on economics. So mom's in rehab, the daughter comes in from Charlotte, flies down from Charlotte, North Carolina, and she finds out today in the care meeting that her mom's going to get released from rehab let's say Friday at noon. And the daughter now has to find a place for mom to get care because mom can't go home and live on her own anymore. So the daughter scrambles. Hopefully she'll find somebody like Kim or an elder law attorney or somebody that knows the communities around and can make recommendations. But if she doesn't, she's going to go out to Dismal Acres and she's going to look and she's going to say, this is not a very nice place. I can't put my mom here. So she goes on down the road to Happy Acres, and when she pulls in there underneath the portico, it's pouring down rain. She walks in, they got Otis Spunkmeyer cookies going. They got the little ladies playing Wii bowling over there. And she goes, this is wonderful. How much does this cost? And they said, for the level of care your mom needs and so forth, they come up with a number. And the daughter immediately looks at mom's checkbook and mom's savings account and goes, oh my gosh, mom's going to be broke in 2 years and 1 month. So instead, she says, Mom, I got good news for you. You're going to move back home with us, back up to Charlotte, and you're going to stay in that back bedroom. And I know when Johnny got divorced, he's back there in the back bedroom playing video games. He's rather depressed, but you're going to share the bathroom with him, and you're okay. All right? That's what she's going to do. And she's only looking at the economics. But I can tell you there aren't any seniors laying out in the gutters begging for alms because they need medical care. We have programs to make sure everyone gets the care they need. Jody's talked about some of those. So state nursing home benefits that are available to you and VA benefits that are available to you. No one's going to get left out in the cold. So we want to make sure that you understand that regardless of where you find yourself, the most important thing that we can focus on is what is the level of care you need. And you're going to get that level of care. Where you get that care might be based partly upon what you can afford to participate and pay toward that care. So choices may be limited, but no one's going to be out on the street. So we want you to be aware of that. The most important thing that we can do is steer you in the right direction to make sure you or your parents are getting the care they need. That's the most important thing we can do. I look at it from the financial and tax perspective because there are economics decisions that need to be made. Jody was talking about, for example, the trust and putting things in the trust. Well, in that trust, as you know, you're going to have investments and so forth, and you need to understand how those investments relate to that plan of care, because you may need that liquidity and flexibility that we talked about to be able to pay for your portion of the care. You may just be paying for a portion of care or all of the care for a portion of time. Again, depending upon your set of facts and the dynamics that you have to work with. So that's just kind of an overview of the considerations that we have to make as how is this going to get paid for? Aging isn't cheap. How's it going to get paid for, right? Okay, so there's a program that the VA has. Do we have any veterans here? Okay, so there's a program the VA have. Thank you for your service, by the way. The VA has for veterans, their spouses or their surviving spouses that will also help pay for care. And here's the beauty of this program. It's the most flexible of the programs because you can hire whoever you want to care for you except for your spouse. The only person you can't hire. You can hire your kids to care for you. How many families do you know where a 55-year-old daughter has stopped working to take care of her parents? And with the elder law attorney putting together a personal services contract, why not hire her to do that or pay her to do that? She stopped putting into her 401k. She stopped contributing to Social Security because she's staying home taking care of her parents. Why not have a contract that will allow her to do that? And maybe even some farther services than that as we get farther down the line. But certainly, the VA says you can hire anybody you want. You can go anywhere you want. We're going to give you a tax-free pension. You use that tax-free pension to pay for care. There's a little catch-22. And that is that the care has to be provided at the time that you make application. And you got to be paying for the care. So it can't be, well, if you give me the money, VA, I'll go someplace and get care. So we set that all in motion at the same time, okay? If you have a service-connected disability, you get what's called compensation, disability compensation. So it's not uncommon for us, in fact, it's very common for our World War II guys that were on Navy ships. Almost all of them have a hearing loss, and they're getting compensation, a minor, small check each month for 10% hearing loss or 20% hearing loss or whatever. That's because their hearing loss is related to their service period. Those big, loud gunships, right? However, the aid and attendance program pays for non-service connected disabilities. So now we're just aging, and we've developed dementia or Alzheimer's, or we've had strokes and we can't care for ourselves anymore at home, et cetera. We need to go to assisted living, whatever level that is, home health care, assisted living, memory care, skilled care. This program is available to help compensate for that, okay? And it pays you directly, and the money goes with you. You go where you want to go. Medicaid, for example, is a provider-payor system. So it pays the provider of the care, and that's a contract between the community and Medicaid. This is not. This is a pension paid directly to you. All right. So the number of people who are eligible for this benefit is pretty astounding. We have 7,091,000 age 65 and older veterans who have served in a period of war. And yet, we also have 4,369,000 surviving spouses, 369,000 surviving spouses, and yet only 4.7% of the people who are eligible for this program have ever applied for it. So it's a pretty well kept secret. Now let me ask you a question. You said you were a veteran, right? Did you get a letter this year talking about your veterans benefits from the VA? No. Did you get one last year? I don't think so. Did you get one in 1978? The point is, you don't. You get out of the service, they give you your papers and say, here's your DD-214 and here's your travel money to get home. And then it's up to you to find out about the rest of those benefits. They might mention something to you about getting a VA home loan. They might mention that. But they really don't talk to you about the benefits. And most people, when they go to the VA hospital, they're looking at all the brochures on the wall and there's all these things about health stuff, and guess what? The aid and attendance isn't in that category. It's in the pension category, and it's not even there. So we have to educate people, and we try to get out and tell people, and the attorneys work with it, and people like Kim work with it, and they say, hey, here's another benefit you might not be aware of, and most people are not. But we only have 4.7% of the people who are eligible applying for it. Okay, so what are these qualifications? The veteran must have served 1 day during a period of war with a total of 90 days of active duty, and anything other than a dishonorable discharge. Dishonorable discharge, your veterans benefits go away. Anything else could be medical discharge or whatever, general discharge, you'd be eligible for this benefit. Not only are you eligible, but your spouse is eligible for a benefit, or your surviving spouse is eligible for a benefit. So even when we're doing pre-planning stuff, I say, look, this is something that you're not going to use right now, but please be aware that it exists, and it should be made part of your plans and discussions with the elder law attorney, so that if you can't communicate that later, she's got that information, it's in your papers, and if your children have to step up with their powers of attorney, they have the ability, now they know about it, and they too can access that benefit. Yes, ma'am?
Divorce spouse covered?
Divorce spouse. Tell me the circumstances. No, let me, that's a good question.
Husband's ex-wife.
Okay, so
He was married when he was married to her when they were in the service.
I can tell you that on rare occasions, yes, but on most occasions, no. But there are rules for that. So we have to know when it occurred, why it occurred, if there was spousal abuse that was alleged or recorded, and all kinds of other things. But it's rare, but it does occur. I know. And it's like, okay, when did that divorce occur, and when did the remarriage, and is the remarriage still in effect, or is there a claim that can be made by another spouse on that person? We have to go look at dates, and we have to look at things. And it's, yeah, go ahead.
On that, if your concern is protecting the children, don't be concerned about that.
Yep.
Because qualifying for aid and attendance has nothing to do with your assets and your plan and everything.
That's correct.
No, I meant for our daughter to take care of her mother, if If they get some other income to help do that, it would help them.
And again, we'd have to look at all of the facts. You know, case management or working on an individual case, there's a reason why those intake forms are done. There's a lot of information we need to know to be able to analyze your particular set of facts and even your family dynamics as to how a plan might work. So coordinating all that together is extremely important. So yes, I mean, there's no specific answer to that without a set of facts, okay? So the veteran or their spouse must need assistance with at least one activity of daily living and some incidental activities of daily living. In other words, it may not be safe for you to be in your environment anymore, and you can't take care of your home, and you have the need for assistance with at least one activity of daily living, then that's a reason for the VA to step in and say, hey, we'll help pay the bills. We'll help do this, provide that assistance, either at home, assisted living, memory care, skilled care, we're going to do that. If you're under the age of 65, the need for assistance does not need to be service connected. You could be motorcycle accident and under 65, and that's fine. Over 65, over 65 doesn't have to be service connected. Under 65, it does need to be service connected, or if you're a full disability, you may be eligible for some of those benefits. So we're not worried about that in our age group, right? All right, so what are the kinds of things that we need to gather? And this is true of any of this planning that you're doing, but specifically with the aid and attendance, we also need the DD-214. Okay, so we need a certified copy of that DD-214. If there are past marriages, we need to know information about past marriages and so forth. Divorces and dates, deaths or whatever. How did a marriage end and terminate? Current Social Security award letter. Most people can tell me exactly how much goes in their checking account for Social Security. What they can't tell me is how much your Social Security benefit is, because you have deductions that come out before that. You have Part B and maybe Part D. And that may vary. That amount varies anywhere from $104.90 up to $180 or so on that Medicare Part B. So we need to know what those are, because VA looks at gross numbers. They look at the gross. Then we get to subtract off as an unreimbursed medical expense what they took out of there. So all we're doing on your income is we're adjusting your total income by what are called unreimbursed medical expense, things that aren't paid for, and your Medicare Part B is not paid for. You're having that deduction out of your check. So we have to have that breakdown. So the Social Security award letter is important. Net worth information, that's your current assets, of course. And I tell people when I first meet with them, I'm a stranger. Don't give me account numbers and all that. Please don't do that for anybody. But give me a general idea of what those assets look like and how they're made up, because then I can advise you from based upon whatever plan that the elder law attorney and I are working on. I can advise you what you can and can't do with those things, or we'll address those liquidity and flexibility issues. We expect things will change. I don't know very many people that start down this healthcare curriculum and their bill stays exactly the same the whole time. Don't know those people. It's going to change. The level of care may change, the cost may change, even the location may change. So we need to know that. Any unreimbursed medical expenses that you may have, there is a physician statement. This is your own doctor. This is not the VA doctor. This is your own doctor telling us about your health. When I have a couple, I usually just go ahead and ask for both of them. It gives me a baseline for the second one. As Jody pointed out, there are situations where the healthy one isn't quite as healthy as we think at times. They become the next patient. I like to say the worst thing that could happen is not one of you, the good Lord, tapping you on the shoulder in the middle of the night and going home. It's both of you being in the nursing home at the same time. That's the most expensive proposition we face. So when that happens, we have a whole different set of rules we want to look at, because the cost becomes astronomical. If she's talking about $8,900 as the divisor here in Florida, that's $18,000 a month. And you have to ask yourself, how many $18,000 checks can I write before I'm completely broke? So that's kind of our worst case scenario, and somewhere between that and what actually happens is what we have to deal with. Okay? There's also a form called a Care Provider Certification of Services. This is the form that the provider of the services fills out. So even if your daughter is the one taking care of you, she has to fill out a form saying, I certify that I'm providing these services, and here's how much I'm getting paid for that. And that's where you want that care provider contract done, personal services contract. So how much can you get? If you're a single veteran, you can get up to $1,830 a month tax-free. So if you're going to Dismal Acres, and Dismal Acres says we're going to charge you $3,000, and Happy Acre says we're going to charge you $4,200, well, you've got $1,800 to pay that $1,200 difference. Okay? A married veteran, or a veteran with one dependent, usually is a married veteran, $2,169 a month. That's half of an assisted living bill in a lot of areas in this country. That's half the bill. And a surviving spouse is $1,176 a month. Now, there are a couple of situations that you could have where you have a elderly veteran who can't care for his spouse. He can't provide the care. If he doesn't have any need for any ADLs or whatever, we're going to look at a spouse who needs care, and the husband just can't provide that care. In which case, we get into a figure down here, $1,432 is a minimum. Quite often, I find out that the VA just goes ahead and goes up here, but I can't say that. This is really the number that they put out there. And then if I have two married veterans, it's almost $36,000 a year that they'll pay toward that. And we do have that all the time because we had a lot of waves and whacks back in the wars, right? Even the Korean War and even the Vietnam War. Don't hear so much about it in the Gulf War, but we usually get, because they could go into combat, we usually get 2 combat veterans. We just don't have the 65 and older, very many of those at this point. So if the monthly cost of all your unreimbursed medical expenses is greater than the monthly income that you have coming in, and there may be even income that can be diverted that doesn't count, then you get the full pension. The idea is that you don't have enough to pay the bill, we're going to give you the pension. So if you got a $4,000 assisted living bill and you only have $3,000 coming in, and you're married, you still get $2,169. Now you have $5,169 coming in and a $4,000 assisted living bill because you have other expenses as well. So you have health insurance premiums and all kinds of other things you might be paying. If, however, at the end of the month you have more money than your expense, then you could be eligible for a partial benefit. And the easy calculation, without getting into too much detail, would be to say, okay, I've got $4,100 coming in, and I've only got $4,000 unreimbursed. I would have gotten $2,169. Now I only get $2,069. That's the easy calculation. Not quite work that way, but it's close. Okay, close enough that we can tell you that a partial payment is still available to you. Again, to offset the cost, because it wouldn't be very fair to a guy that's $1 short gets the full $2,000, and a guy that's $1 over doesn't get a dime. That wouldn't be very fair. So this partial payment, aid and attendance pension payment is available as well. And we have a lot of those. And we have a lot of them that start off with partial that go to full because expenses go up. So we have to notify them when expenses go up or income changes. It's not how much income the veteran has, it's their income in relation to those unreimbursed medical expenses. So we're going to, on that intake form, we're going to want to know how much you're paying Humana or Blue Cross Blue Shield or someone every month for your care. How much is coming out of your paycheck or your Social Security check for Medicare Part B and so forth. And sometimes you even have, coming out of pensions, you have a gross amount and then you're still paying something out of your pension toward care, et cetera. We want to know all those unreimbursed expenses. How much are you spending on diabetic supplies? How much are you spending over at Happy Acres? Or how much are you paying somebody to provide for you? Those are the things that we have to work with. Sometimes you don't know what those numbers are yet because you're just starting down this process. And that's where, again, working with the daughter who's going to work, how much care is she providing? Now, I have some people fill out the form saying, the daughter says, I'm doing 24 hours a day, 7 days a week, and I'm charging $700 a month. That's a pretty good rate. I don't know, what's the average rate for home aides? Around 21?
About 21.
Yeah, 21. Now, try to have somebody $21 an hour, 24 hours a day, 7 days a week, and it's going to come out to $15,000 a month. Okay, that's what it really costs to have that kind of assistance, unless you hire somebody private, just a live-in. I've seen that done too. So these are some of these expenses. One of the things that they don't allow us to include is the pharmaceutical expenses of the veteran, because their assumption is that the veteran is going to start getting their pharmaceuticals from the VA. They'll let us include the pharmaceutical expenses of a spouse out of pocket, but I've seen a lot of them submitted with the pharmaceuticals of the, yes, go ahead.
So that brings up a question that I had last week.
Yes.
I'm going to put you on the spot.
All right.
So Florida has just passed a law saying medicinal marijuana is now legal. If a
I saw a place I drove by so I could get a card.
Yeah.
I've never even tried this stuff. I don't.
So obviously there's an out-of-pocket cost for
Sure.
that if it's prescribed by the doctor, and I know you just said the veteran can't, but let's say it's the spouse who is now purchasing legally medical marijuana, but federally, which regulates VA, it is not legal. So can they use that as a medical expense for VA?
That sounds like a legal question, and I don't answer legal
I don't know
questions.
the answer to it.
I don't either. It's funny because you talked about the proposed rules, and I testified in 2012 at the Joint Subcommittee on Veterans Affairs on those proposed rules and some of the things that they were talking about. And nobody wants to make a decision. That's the problem with all the guys. I also said if committees were a great way to make decisions, Congress with 535 members ought to be the best committee we've ever seen, right? They don't want to vote. They want to be on the record. So I have no idea how they would handle that. I mean, that's an interesting question.
Let's find a test case and see.
Yeah, and all right. One of you guys need to get a medical marijuana card and start buying. There you go. But the assumption is that the veteran themselves would be getting, but the veteran spouse can't get their medicine through the VA. So that being the case, then they'll let us count the pharmaceutical expenses of the spouse, but not the veteran themselves. So the idea is also that we need recurring medical-related expenses. So I have people say, well, I got hearing aids last year. Well, you're going to get hearing aids this year because your numbers might be different. That $3,500 might be a big difference between eligibility numbers. So again, we want to look at those recurring medical expenses. And of course, any home care, even non-medical home care, family caregivers, you can receive care at home. You can hire who you want. I've often said you can't hire your spouse because they'll do it for love, but your kids will do it for money. So, pay them. But I feel sad for some of these gals who do quit their job and take care of their parents. It's not an easy job. That's a task in and of itself. But certainly if you have the ability to compensate them for that, then let's do that. Because down the road, by the way, that's also, when you think about advanced Medicaid planning, that's a way of legitimately moving some assets out of over here they're going to be countable to over here where they're not going to be countable. Because we're paying for her, it's a legitimate expense for her to take care of her parents. So those are all considerations that we have to look at. Exempt assets include the home, car, irrevocable prepaid funeral contracts, or personal effects. Picture?
That's my grandfather.
There you go. Everything else is really countable. So just like the Medicaid side, we have these non-countable assets, unavailable assets, and countable assets. We have the same thing here. And the VA looks at some things differently. We might have a business that's operating on the Medicaid side, and the income from the business is countable. Or VA says, well, they're both countable. It's an asset and an income. So we have to look at that. And there's a little bit of confusion about how much you can keep in your own name and qualify for Medicaid. Remember when Jody said there's no look back? You can make a change today. If I've got X and X is too much, I can put X over here in my irrevocable trust and I can qualify for VA tomorrow. No look back. I got a problem with Medicaid and I got to make sure then that I can react to that should Medicaid become an issue. But there's no look back. So if you can have some assets, what's the number you can have? Well, in the Medicaid or in the VA adjudicator's manual, there's a reference to two numbers, $80,000 for a married couple and $50,000 for a single person. And at that point in time, it's supposed to be, well, that's a safe number. But I can tell you that's not a real number. Because the adjudicator takes a look at your life expectancy, your actual life expectancy, not the tabular life expectancy like we use in Medicaid, because they look at not only mortality but morbidity. What are the illnesses? How many of those, if you're short $1,000 a month, how many of those $1,000 checks can you write? How long are you expected to live? Oh, you have plenty of $1,000 checks. So they can actually adjust it downward. One of the proposed rules, when Jody was talking about some of the proposed rules, one of the proposed rules is to use a Medicaid number for the Community Spouse Resource Allowance. I hope they adopt that, because I hope we have a hard number we can deal with, because right now I have to play a guessing game. What is that adjudicator going to look at, and what number is he going to say? Now, that doesn't mean that you give up all your assets and you don't have any money to live on anymore. That's not how that works. And the attorney would tell you the same thing. The controls are placed in the trust. So that what we have to do is we have to kind of play a guessing game on that mortality right now. And I wish it was different, but your set of facts will help determine that. Yes, ma'am.
If you have, let's say, both IRA and the non-qualified annuities, so you've got, some income coming in every month, and that's less than your expenses, so I assume based on that you would get paid. But do they look at the balance of the annuity?
Unlike Medicaid, who does not look at the asset base, you have to be taking the required minimum distribution, and that depends upon the state, by the way, where you're doing the planning, because it's different. In Indiana, for example, the spouse's IRA is exempt, and the Medicaid applicant's IRA is not exempt. Even if they are taking RMD, it's the asset value itself.
I'm saying it's past the RMD.
Yeah.
You've already selected.
Oh, you've got an income stream? Are you annuitized them? Have you annuitized them?
5 years we will, so I'm just saying, in the future,
Okay, well,
it's annuitized.
yeah, let's assume that you've annuitized it, now it's an income stream, and you no longer have access to the asset value. Then that's fine. That's just going to count on the income side. But if you have a IRA that you're just taking the required minimum distribution out of, they're going to count both sides.
The VA.
So you-
The VA, not Medicaid.
But let's say somebody was getting ill, then you could convert it.
We could convert it to income stream. And that's if it makes sense.
Yeah.
That's assuming it makes sense with the rest of the plan, because there might be other things that you could do.
The idea is to save money for the
Yeah.
spouse to live.
Yeah. Well, look, like in Indiana, here's a common thing that we do, and I'm just going to throw this out. I know you guys aren't in Indiana, but it just works in other states as well. So if I go in the nursing home and I've got an IRA, my IRA goes with me to the nursing home. It's an asset that's got to be, it's part of the spend down calculation. It's not exempt. But I could get my IRA over to my wife 2 different ways to where it doesn't count against mine. The first one is if it was an income stream, I could ask, or I could use a company that would say, hey, Mr. Wedmore's in the nursing home. We're going to ask that company to start making the check out to Mrs. Wedmore every month, even though I'm going to get the 1099 at the end of the year, because Medicaid says to determine whose income it is, look at the name on the check. That check is now made out to Mrs. Wedmore, and it's no longer an asset that counts against me because the income is being paid to her. Okay, that can be done in some states, and there are states that have approved that because that's kind of a general rule. Then there's also this. We could go to a family court and have what's called a qualified domestic relations order issued, where the court orders the company to give my IRA to my wife, just like what happened in a divorce, only it'd usually be half. But they do the whole thing. Because if it's exempt on her side of the equation, the argument of the court is, look, these spousal impoverishment protections are designed to protect her, and that's a major asset, so that could be done. Now, these aren't things that I do. These are things elder law attorneys do, so I don't.
And let me be very clear, for Medicaid in Florida, you could ignore all of that.
Yeah, because it's not it's not even necessary.
In Florida,
It's-
both
that's-
spouses.
Yeah,
IRA.
yeah. In Florida, it's not. That's why I said I wanted to clarify. That was an Indiana rule.
Medicaid.
Yeah, in Indiana, that's a separate rule because my IRA would be countable, but her IRA would not be countable. Well, then get rid of my IRA and give it to her.
But for VA in Florida,
For VA everywhere, it's countable.
Yes, and
if it's been annuitized?
Not if it's been a new.
no, then the income is.
Because it's only the income side and the rest of it can.
Yeah, here's a
Remaining payments would continue going to the.
yeah. So
Once you annuitize it, there's nothing left in the bucket.
there's nothing that it's
Well,
a,
it's income for life with both spouses.
Right, so the income continues.
the income counts.
Well,
Yeah.
you can annuitize that.
So there's a big distinction, by the way, between Medicaid and VA that we haven't covered here. Medicaid, when you're applying for Medicaid, the income of the Medicaid applicant is the only thing that counts toward their eligibility. The income of the spouse does not count. So the Medicaid applicant's income is the part that you deal with when you're talking about the Miller Trust and those kinds of things. But on VA, it's the entire household income, all income together and all assets together. In Medicaid, it's all incomes are separate, but assets are joint. So that's the difference. That's another difference between the two, and why, again, you've got to work with somebody who understands that process of how that's going to work for your set of facts. So even when we were talking about the income, some reassigned income or whatever, that might not be the best answer. I don't know until we know all the facts.
You said for VA, it's combined income of the income and assets?
Yes,
Medicaid,
income and assets both are.
Medicaid is separate.
Incomes are separate, assets are joint. So the assumption is, Medicaid looks at the assumption that the assets are all counted together for calculation of spousal impoverishment, but the incomes are separate. Only the Medicaid applicant's income counts toward them.
Those assets were separate prior to marriage?
Yeah. So the question is, even if some of those assets were separate prior to marriage.
Yes.
It doesn't matter. They don't believe in prenuptials, postnuptials, antenuptials. That doesn't matter to them. All assets are considered jointly held. Incomes are separate. So when we do our calculation, again, we have to look at that. But VA says, well, we're going to count all the income and we're going to count all the assets, and it's all in one big pool. So again, this isn't the advantage to this is that you can make whatever changes necessary to meet their qualification tomorrow. There is no look back. But we have to consider the possibility that down the road we're going to be looking at some much bigger bills, and state nursing home benefits through Medicaid, the age blind disabled, are probably going to be likely. What's the probability that you're going to need extended care when you're 65 years old? What's the probability that you, at some point during your life, will need some form of extended care from rehab all the way through?
At age 65?
At 65 or older. 70%. When you reach 85, it's 85%. 85% of the people who reach 85 are going to need some extended care. Now, we'll insure our house where we have a 1% probability of loss, possibility of loss, and not a 85% probability of care. Most people just don't have long-term care insurance. I wish they did, but they don't. And we have to react to that. We help them through that process. Okay, figuring out how it's going to get paid for. So with the 5-year look back, just make sure you're working with whatever team you're working with, that they understand the rules and the regulations, and that they're thinking down the road. They're not just, I've met guys who do VA benefits, and their solution is, here, we'll do this today, and we'll put that money over there. And by the way, when you need your money, it's going to cost you money to get out of there because they put surrender charges or other things on there. I don't want anybody to ever have to pay to access their own money. So make sure they understand the rules, because the probability is we're going through this continuum of care. It's going to get more expensive. And when do we have to be able to reach over here to have some of those funds to meet our ongoing obligations? And I don't want you to have to pay money to get your own money back. Okay? If you work with a team, somebody who's looking at it from the healthcare perspective, somebody who's looking from the legal perspective, somebody who understands the financial perspective, you're going to put together a plan that's a healthy plan. You're going to know when to flip the light switches for the various things that happen, because things are going to change. And all those tools are built in. They should be built into the legal side. They should be built into the financial side. They should be, of course, built into the health side. So when things change, somebody knows what to do. That's that other question earlier about having the power of attorney. You should have a copy, but maybe the kid's not, so they don't, But the idea is somebody has to be able to step in and do those things, and you have to have the right tools to make that happen. So that's the key part. All right, that's the end of mine. Anything else you want me to cover? Sorry about that.
I was going to say, as you can see by looking at this New Year's resolution, that you see that everything fits together and everybody works as a team to help keep all guys very much. If you have any questions, I will open up the floor for Jody and also for Kevin, or if you have any questions for myself. We also had some handouts that the young lady in the back gave you when you came in. These are some things that I give to my families. This one here is an individual assisted living comparison sheet. So when you are going around